What MSPs need to know about the Kaseya Ransomware attack. This topic on today's MSP Zone.
You're entering the MSP Zone, a podcast for the managed services community, covering news, analysis, and interviews from around the globe. Elevate your MSP game by staying in the MSP Zone. And now, your host, Charles Weaver.
Good day, everyone. Hope you are all doing well. We have a big show for you today. We are going to be talking to our friend Rob Scott, who is going to be, I don't know any other way to say it, but we're going to be tackling some really important stuff today. Some important questions, important topics. You're not going to want to miss this because we're going to have a lot of really useful stuff that you're going to be, you need to know. You need to think about this stuff, take it back into your MSP practice, deliberate hard, and make some changes too, because a lot of the stuff we like to do is for listeners of the MSP Zone and followers of both Rob and MSP Alliance, we like to give you practical advice, things that you can really take back to your businesses and implement, with hopefully great effect. So today we are talking kind of an extension of what we talked about in the last episode when I gave you my thoughts about the Kaseya incident. We're not going to gang up on Kaseya. We are going to simply do a I hope, very straightforward analysis and review of what we seem to be getting as emerging details of this incident. It is not something that we intend to hide from as an industry, as a profession. We cannot do that. We need to address this head on, and we need to make sure that we really understand what happened and act accordingly in order to prevent this thing from happening again in the future, number one. And number two, give the MSPs and their customers enough information so that they can be very transparent and very open about what happened and how to improve upon it, because that is I think, one of the most important goals that we can take from this type of a situation. So we have Rob Scott from Scott & Scott out of Dallas, Texas, actually Southlake, Texas. Rob, welcome back to MSP Zone.
Thank you, Charlie. Good to be with you.
So I know you and I have been, talking a lot, exchanging a lot of back and forth comments about this since it happened. First of all, fair warning, I think this is probably going to be a multi-part series here, just because the volume of information and material that we have to cover is not going to be enough for a 30-minute-ish segment. So bear with us. Rob and I are going to do our best to give you kind of the overview of what we're seeing evolve here. Rob, I want to start off by saying you are not providing any legal advice to any of the members. If they have questions, they can certainly contact you in your law firm. You provide this type of counsel to a lot of MSPs, do you not?
Well, yeah, we represent a number of MSPs, many of which, as you know, have used Kaseya's products and have been either affected or potentially affected by these incidents. And so we are following the issues closely and are consulting with members via the MSP Alliance hotline, which the members have the ability to call for a complimentary legal assessment or review. And so I would say that if any MSPs are out there who have been affected by the Kaseya ransomware attack or are concerned about the legal issues involved, to please call the hotline and speak to an attorney that can assist you.
Absolutely. So if you are impacted, we heartily encourage you to do that. A lot of MSP Alliance members use Rob and his firm for a variety of legal work. Rob, let's dive into this, because this is an emerging situation. And again, our friends over at Kaseya, I say that because we have a lot of friends. We have a lot of people that we know who work not just in Kaseya, but all the other companies that supply hardware and software technology to the MSPs, to the global MSP community. It's a vibrant community. We couldn't do the work. MSPs couldn't do the work without those companies. But this is a serious thing. This is an unavoidable thing. We haven't talked to you since this happened. You want to give us your random thoughts about what you thought of when you first heard about this attack?
Well, initially, I really wasn't that focused on the implications of it, because, let's be candid, we all hear about data breach incidents and ransomware attacks every day. And it really didn't dawn on me, the significance of this until a day or two into it. And since then, me and my team have been focusing very carefully on a study of the licensing agreement from Kaseya, and really trying to understand, okay, if there's an MSP who's been injured and their customers have been injured, who has what kinds of claims against whom, and what do we know about the facts that would indicate whether a particular MSP or end user would have a good case. And so in that regard, we've been following the news that's come out very carefully, and every time we learn additional facts, we're vetting those facts against the language in the agreements and trying to understand, okay, if someone is been injured from ransomware attack, what should they do next? What steps need to be taken relative to potential Florida or other state laws, breach notification obligations, as well as the right to recover or notify potential insurance carriers, as well as preserving evidence and evaluating potential claims against Kaseya for their involvement in the situation. So that we've been obviously very busy with understanding the legal aspects, but we're also mindful of the impacts on the industry, which are, in my opinion, now going to be much more widespread than what I originally anticipated.
Okay. So the obvious first thing is there could be a data breach notification, right? That being one of the more fundamental legislative or regulatory items that impact MSPs and customers alike. I mean, certainly it impacts Kaseya, but it certainly could impact all the impacted MSPs. The first question really is, and you and I are going to get into the analysis of what is actually happening with that breach, but do you sense that this is just the on-premise VSA MSPs and that would need to do this, or are the cloud VSA customers, partners were not involved, as I understand it? Would you say that they are off the hook from a data breach notification?
I would say if it's shown that there was no compromise or disclosure of data, then they're off the hook. So the technical, forensic examination will, determine whether or not they're off the hook or not. The premise you gave was they weren't involved. Based on that premise, I would think there would be no notice obligation. But you would need the forensics to be able to bear that out. You couldn't rely, for example, on a public statement from Kaseya to rule out the obligation to give notice. Okay. The other thing that's important for MSPs to understand is if the MSP's customer has a compromise of data, that's not a notice obligation by the MSP. The way that data breach obligations work in the vast majority of the states, if not all, is that the end user customer is the one that's owed an obligation. So if there's a compromise of data of the MSP's customer, then the MSP gives notice to that customer. That customer's customers are beyond the reach of the MSP's notice obligation.
All right. Can you say that again? Because I want to make sure everybody understands and knows what you're talking about. We're talking about data breach notification, and in the situation here where Kaseya, let's assume that Kaseya is the responsible party here for the breach, but it impacts a downstream MSP. You're saying the MSP would be required, or is Kaseya required to make the breach notification?
Kaseya is responsible to give the breach notification to its customers. In the context of the MSPs, many of the customers of Kaseya are the MSPs, not the end users. And so Kaseya would owe an obligation, if any, to the MSPs. The MSPs would owe an obligation, if any, to their end user customers. But the end user customer owes the obligation to its customers.
So it's a ripple effect. So Kaseya notifies the impacted MSP, the impacted MSP notifies the impacted customer notifies their impacted user, and so on and so on and so on.
And then lawsuits ensue to determine who pays for all that.
Because there's a cost involved in just the notification.
Yeah, and just because, for example, hypothetically, and I'm not saying this is the case, but hypothetically, let's say Kaseya was legally responsible. And let's say the end user has to give notice to its users. The fact that Kaseya was ultimately to be determined legally responsible does not alleviate the obligation of the end user to give notice to its customers now.
So what happens
is everybody gives the notices that they're obligated to give, and then either the parties or the insurance companies or a combination of both try to resolve who pays what.
I have to think, Rob, that there is a lot of complexity here, and this may, if I'm an MSP of average size, I would like some help. I could use some assistance if I even engage a firm such as yours. That's going to have a financial cost to it. What's the role of insurance in this? Is this a covered insurance event in the sense of an MSP that might have a cyber liability policy?
I believe that our fees would be covered in the context of, for example, many of the members have the Beasley insurance. And I believe that this would be an incident that would be reportable and potentially coverable. And, we are approved counsel on those policies. As you know, I was the one that worked with you and Lloyd's of London to put these policies together in 2008. So if you are an MSP and you have MSP Alliance Cloud and MSP Insurance, and or tech, media, professional liability insurance through someone else, and you've been affected, you likely have coverage for forensics, for legal, to review what your obligations are vis-a-vis your customers and potential breach notification, and even potentially communications with law enforcement, as well as if there's a reputational concern, to engage with crisis management and public relations, all of which should be covered is covered under the MSP Alliance insurance program, and would likely be covered under many professional liability policies involving tech, or tech professional cyber liability.
All right, let's talk about steps taken, because if we're talking about insurance, call the lawyers, is there a sequence to which where the MSPs ought to take this step first before going to the next one? Should they call you first? Should they call the insurance? What's the guidance?
Well, first thing is, triaging the impact and preserving the evidence related to that. And So the first thing is, which of your customers is affected?
Mm-hmm.
What has been the impact? That's really the first priority, is the investigation, the containment, and the triaging of, okay, what happened? How did it impact us? How would we go about quantifying what that injury would look like in terms of dollars? And then I think it's a call to a lawyer that would help them evaluate the various aspects of what they should be concerned about, which is, how is this impacting me? How is it impacting my customers? What legal obligations do I have? And what rights do I have to recover any injuries that me or my customers have sustained?
So, all right. So obviously, the remediation, the forensics, and the getting yourself as an MSP, and then getting your customers up and operational and clean and free and clear of this of any ransomware remnants is obviously step number one. But then you say contact legal counsel, because at least in your case, you would be able to say, okay, do you have the MSP Alliance insurance? Do you? If you do, then this gives us some options. If you don't have cyber at all, that may be a different financial exposure to the MSP for getting assistance like legal counsel.
Correct. In one instance, the fees would be likely reimbursed by the carrier. In the other instance, the client would be paying the fees, out of pocket. And obviously, there's a difference there, right? And that's why part of the reasons we created the insurance and why we recommend it is for situations like this. But just because you don't have insurance doesn't mean you don't have to look at these issues.
Understood.
Yeah.
So I want to swing our attention a little bit to, because like if you've been listening to MSP Zone for in any time in the last year, this is not new. Rob, I mean, you and I have been talking about this, and it's not just in the last year that we've been talking on MSP Zone. We've been talking about this for 20 years. We've been talking about this a lot. So this is not new. It shouldn't be new to those of you who are familiar with us. We have been not preaching, but we've been talking to you guys and saying, look, this is the day's coming and the day's here. I would like to turn our attention, Rob, if we can, to the multiple press accounts. And there's one in particular. It's a Bloomberg story, I think, that just came out maybe a few days ago. And I want to be very upfront, right? These are allegations that are, as far as I'm concerned, not proven. This is reporting, so it's independently verifiable. You can read the article. We'll post a copy of the article out there. You guys should read this. But this gets to the issue of responsibility of not just Kaseya, but all vendors, and the allocation of risk and the allocation and the ability to go after remediation from a party like a Kaseya. Rob, there are obvious contract limitations, right? Exclusions of liability or limitations of liability and other legal concepts that limit the other party's ability to do certain things. What can you speak briefly about your experience and knowledge of not just Kaseya, but maybe all of these different vendors and how they approach that contract?
Well, yeah, and that's a good way to say it. And I think the fair way to say it, with respect from the vendor's perspective, is we've got a tool here. You could use it. We are not taking responsibility for your use of the tool. Customer data means your data and your end user customer's data, and you're responsible for it. If it goes missing, but for our gross negligence or willful or intentional misconduct, our obligations are going to be either completely, responsibility to pay is either completely excluded or severely limited. And that, the essence of the concept is that the vendor has a relationship with the MSP. It has no duty or contractual privity with the end user. And if something bad happens with the end user's data and it's due to a criminal act of third parties, like in this situation, the vendor is not on the hook for that. And to the full extent of the law, and then only will pay a small amount that's tied to revenues received.
All right, so Rob, I want to stop you right there. When you talk about a criminal act, this was undoubtedly a criminal act by the group alleged to have done this, right? The group out of Moscow, Russia, a criminal cyber gang who has done this type of thing before. That is a overt criminal act. Is that the act that you're talking about, or would this have to be a Kaseya criminal act, which we are not saying happened?
No. Correct. What I'm saying is, the law rarely will impose liability on a party who itself is a victim of a criminal act by a third party. I mean, if you think about Kaseya, right? I mean, they've been, they've been the victim of a criminal attack.
Right.
I mean, if things that have been reported are true, this ransomware attack is the act of third parties to the contract. It's not the MSP, it's not Kaseya, and therefore the question is, who, if anyone, is responsible for a ransomware attack that's perpetrated by third parties? And in Kaseya's contract, for example, there are numerous provisions that make it clear that the intent of the contract is that Kaseya does not warrant the results of the use, that the software is bug-free, or that the software will provide any protection against viruses or any network intrusion or security breach, or that the use of the software will be uninterrupted or error-free. So, I mean, they make it abundantly clear, in the agreement, that they don't really take any legal responsibility, or if they take any, it's very limited, and that is the state of the industry. And again, the terms of this contract are market in many ways. The problem is, and I think you and I agree on this, that MSPs need to choose vendors that are willing to see the market in a different way in light of what's happened.
Well, to channel my inner Phil Donahue here, Rob, you're telling me that there's a whole bunch of MSPs who are just impacted by a fairly significant data breach, at least in terms of Kaseya's exposure. They've been, exposed to a fairly significant breach, and the MSPs are prohibited from recovering any type of damages or restitution in this, based on what you just said is in the Kaseya contract.
I'm not saying any.
Difficult.
I'm not saying any, but one of the things that I would say that will be very challenging is to the extent that the MSP is trying to bring, claims against Kaseya that are based on injuries sustained by its end users. The agreement is pretty clear that such a case is the responsibility of the MSP. If that's enforceable, then it could be nothing.
Rob, why does that sound so unfair to me?
What's that?
Why does that sound so unfair? I mean, MSPs listening to this have got to be saying, so we did nothing wrong. We used the product like it was supposed to be used, and it backfires. Something bad, admittedly, well, I don't want to say admittedly. At this point, let's assume that it wasn't Kaseya's fault. The Bloomberg article, I'm going to get to it next, suggests something otherwise. But let's assume that it wasn't Kaseya's fault. The MSP in this scenario is just out of luck. How is that fair or equitable in any stretch of the imagination?
I don't think it's fair. I'm just, if I'm a judge in a court case, I'm going to be looking at the agreement between the parties.
And I'm going to be trying to understand, what does the agreement say? And, I'm looking now at the limitation of liability in Kaseya's agreement, and it's very strict. And it says there, you acknowledge and agree that Kaseya would not enter into this agreement unless it could rely on the limitations described in this paragraph. Kaseya would say, we couldn't offer the services for the price that we do and be competitive with the other tools vendors, which, by the way, limit their liability in similar or identical ways.
So they're all following the same playbook here, is what you're saying.
Correct.
Okay.
That's what I'm saying. And I'm not saying that a court would uphold it. I'm not saying that it's enforceable. I'm not saying that.
No, what? So Rob,
find it to be an overreach.
I don't want to go through contracts, first year law school contracts for everybody, but in a short version, why would a judge really say that this type of an agreement might not be enforceable?
Most jurisdictions have a public policy against parties completely exculpating themselves from legal responsibility in the context of a contract.
Could you rephrase that in a non-legalistic fashion, please?
You can't go into a contract and say, I take no legal responsibility if something goes wrong.
So I can't say to you, let's sign a deal. You're a party, I'm a party, but under no circumstances, there's no scenario on the planet, in the universe, where I'm going to be responsible for anything. That type of a claim cannot generally be enforced, is what you're saying.
What I'm saying is, in certain circumstances, a court could look at those terms and say, we're not going to enforce that because we have a public policy of requiring people to be legally responsible for their own conduct. In this case, the question is not, is Kaseya going to have to be an insurer for somebody else's conduct? The question will be, was Kaseya grossly negligent in its handling of security issues, such that a failure to act as a reasonably prudent company under these circumstances resulted in injuries to MSPs and end users? That will have to be proven. The question here is, if proven, will the court say, in light of the contract, even if proven that it's their fault, they don't have to pay?
Right.
And that's the question here.
All right. So I don't want to litigate this, but I want this is useful for MSPs who are just out there trying to make sense of everything and try to figure out what next steps are. Even if you're not a Kaseya user, I think there's ample evidence that we've been phones are ringing off the hook with MSPs of all sizes and shapes, regardless of whether they use Kaseya. Some do, some don't, who are just generally, worried about how they can prevent this from happening. Gross negligence is obviously a term that does exist inside the Kaseya agreement, correct?
That's correct.
I don't even bring that story up from 2016, but can you generally describe in lay terms what gross negligence as a concept means?
If you are driving your car and you get distracted by your phone and you're in an accident, that's ordinary negligence. If you drink 2 bottles of wine and get in your car and drive and have an accident, that's gross negligence. The difference is the mental culpability of your behavior. One is an accident. The other is something that you did that shows that you had a gross disregard for somebody else's either physical, welfare, or in this instance, for the security of customer data.
Okay. All right. So I think that makes sense. Hopefully most of our listeners out there make sense of that, even the ones that aren't lawyers. Could you walk us through, I'm sure you've read, just like I have, the Bloomberg article. And again, I want to be very sensitive about making accusations that haven't been proven, because all we're doing, for the record, is we're retelling what is already in the public domain from this Bloomberg, and I think it's in a few other source locations as well. What is the Bloomberg article essentially saying that might be relevant to not only the gross negligence issue, but also some of the other restitution issues that we've been discussing here?
The Bloomberg article is significant because it contains reports of allegations by Kaseya employees who claim to have knowledge of the circumstances, suggesting that Kaseya knew and was on notice of security vulnerabilities, that if they took action in response to being alerted to such vulnerabilities, that it might have prevented these attacks.
Might have, not guaranteed would have, but basically they allege, whoever they is, the parties are not known. Are they the former employees?
Not, I have not had any, knowledge of who they are or have read anything that discloses their identities other than in a generic way.
So an unnamed source in this Bloomberg article says, we, the former employees, told Kaseya, you got some problems, you got some breaches, these need to be fixed. They weren't fixed, and allegedly as a result or shortly thereafter, they're let go. Does that type of, assuming that's true, and that's a big assumption, assuming those facts are true, does that make the gross negligence issue, does it change it? Does it make it more relevant to an MSP?
Yeah, 100%. I mean, these facts would be critical to the determination of whether or not you could establish gross negligence. And the reason would be, the devil's in the details. What did they know?
Yeah.
Because the question will be, what should they have done? We're gonna compare them to a reasonable person under the circumstances. And I would tell you, in my opinion, just general awareness of vulnerabilities with no ability to tie any nexus between those general vulnerabilities and these attacks would not be sufficient.
All right. So someone just saying, hey, there's a vulnerability, it doesn't mean that, all right, as of right now, you're liable for anything that happens, because that assumes a lot, is what you're saying.
Yeah, there's going to have to be some causal nexus between the specific vulnerabilities that they were warned about and how this attack was perpetrated. If you could show, for example, that A, these allegations are true that are in this report, and B, that the vulnerabilities that were being brought to the attention of the leadership at Kaseya were the same vulnerabilities that resulted in this attack, then I think you've got a very strong basis for establishing gross negligence. If you don't have that, these facts are relevant, but they will not be conclusive.
Okay. So we hope that these facts are not true, right? There's no names. I can see why they wouldn't want to include that information, but at the same time, this is a fairly serious allegation to make, and not to have your name attached to it. I mean, I see both sides of of that argument, but I can't help but think that there's a bigger public policy discussion that we have to have, and as the MSP Alliance, we have to have this conversation, which is not just Kaseya, but all the other vendors. Not just RMM, ticketing, backup, security, SOC, SIM as a service, firewall, everybody who delivers goods and services downstream through MSPs. This is not just a Kaseya problem. We keep saying that, and it's not because we're trying to let Kaseya off the hook or the opposite. We're not. We just want to be fair, but we want to be taking what we can learn from this and making positive change. So, Rob, where do we stand as of right now? I mean, we're over a week since this thing happened. So has the hole been breached? First of all, has the security vulnerability been plugged that you're aware of?
My understanding is that the attack is contained, but I have no personal knowledge of the forensic activity that's going on, and so I really have no opinion other than the reports have suggested that the vulnerability has been contained.
So we do know from public reports, Kaseya has engaged, I think, FireEye to come in and do the forensic evaluation. So presumably they're going to be, getting some information about how this happened. But the details of that aren't necessarily going to be public, will they?
No, what typically will happen is the lawyers for the affected party will supervise the forensic examination and therefore make it a part of the attorney work product. And what will happen as a result then is for the public consumption redacted summary of the forensic report will be included in the press release, which is sort of the most typical way that this gets handled.
So we can assume that will contain very carefully scripted disclosures that almost certainly will not be helpful to the MSPs in guiding them as to what happened or what they should do. Is that fair to say or not fair to say?
I think it could be helpful in guiding them, but I don't think they can rely on that exclusively.
Okay.
For example, if they knew that a customer had been affected and there was something in the report that said that they hadn't been, they can't rely on that report in light of the fact that they already knew that there's an issue. I mean, so what the report can do is in some ways rule in who's been affected. I don't think forensic reports are as good at ruling out. But in the case of a ransomware attack, if there's no other access other than the machines that were subject to the ransomware, it's pretty easy to identify who's been affected.
So that we might be able to take from such a report when it comes out that, hey, look, we know that the cloud VSA MSPs and therefore customers were not impacted, right?
That's correct.
But it may not say all the on-premise VSA, because I certainly, we're hearing stories of MSPs that use that tool on-premise and they weren't impacted, meaning they took it offline appropriately when they were notified and they just had other means of performing their managed services. And I think that's likely going to be the case hopefully a lot end up being that case. But we are not aware of.
The would be that the real question, I think, from a forensic perspective for me is there something that triggers a notice obligation, such as a compromise that didn't result in ransomware, but is still a trigger for a breach notification?
What would that be? So you're saying that they weren't ransomed?
That would be that they had a user account that was able to get onto a network or a computer, but that didn't yet deploy the ransomware.
So the burglar was in the house, but they didn't actually steal anything. That's the equivalent?
Correct.
All right. So they gained access to the account. They could have pulled the trigger on the ransomware execution, but they didn't. But that's still something that has to be disclosed.
Potentially.
Okay. So, all right. So we're going a little bit over, Rob, and we got a lot of, look, we haven't even talked about what the next steps are and what MSPs ought to be doing, because I guarantee you there's now MSPs, not just talking to Kaseya, but all the other, MSP platform tools, and they're being presented with contracts. I know you've got some guidance for them coming up in light of what we are talking about today. Would you mind coming onto the program in the near future so we can continue this for episode 2?
I'd love to, Charles, anytime.
So I just want to recap this. So look, I've not heard of anybody who was had their data locked up, right? I've heard those stories in the past, so it's not like we don't get access to this data, but I am not personally aware of any MSP or an MSP's customer who got the ransom and actually, had their data encrypted. I'm hoping that that's the case, but nevertheless, this does bring up a lot of issues. Rob, again, back to the early guidance in the program, we we went over the likelihood that a data breach notification event is in the future for a lot of these MSPs, even if they didn't actually have their customer data or their own data locked up. They're going to have to make some disclosures, and at some point, insurance and or legal counsel is going to have to be involved. I know you're probably already working with a number of MSP Alliance members. What's the best way for people to reach out to you if they have questions about this?
We any way that's convenient for them. They can call the MSP Alliance hotline. They can call the office. They can email me directly. They can visit our website, scottandscottllp.com. But any way that's convenient for them to reach out, we're here. We're ready to help MSPs that are affected by this situation. And as you say, this is not going away anytime soon.
Yeah. Let's just keep our fingers crossed. And no matter what caused this and what led up to this event, let's hope that the damage was minimal or non-existent. I mean, when I say non-existent, meaning I hope that people didn't actually have their systems compromised to the point where they couldn't restore valid copies. But I think we're gonna be hearing those stories, and whether that's true or not over the next coming weeks and months, something tells me. But Rob, thank you very much again for coming on and participating in this, and we'll have you on for the next episode of this topic to talk about maybe what steps you as an MSP might want to take when you are presented with that vendor managed services agreement, and whether you should sign it or not, and what things you might want to start asking for. That's going to be a very important conversation. You don't want to miss that one. Rob, again, thanks for coming on the program today.
Thank you, Charles. We'll talk to you soon.
All right, folks, that's it for today's episode. Hope you enjoyed it. Leave a comment. Contact us at mspzone@mspalliance.com. If you have a question, you want to be on the program, you want to join Rob and I in this ongoing discussion. It's very important. As always, stay safe. Until next time, this is Charles Weaver with MSP Zone.
Thanks for listening. If you enjoyed today's episode, please give us a like. Make sure you are subscribed to the podcast so you will get notified when future episodes are released. We will see you next time in the MSP Zone.